The Rivers State High Court has ordered the governor of Rivers State, Simi Fubara, the state chief judge and the attorney general and commissioner of justice, not to act on any resolutions forwarded to them by the 25 members of the State House of Assembly whose seats have been declared vacant. Justice Charles Wali, in an interlocutory ruling dated May 30, 2024, also held that the seats of the affected lawmakers remain vacant. The judge also ordered the lawmakers to stop parading themselves as lawmakers until the determination of the substantive case. Joining us now on the morning show from Port Harcourt, Rivers State, is Chief Festus Ogwuche, an indigenous of the state, a legal practitioner, human rights activist, and good governance advocate. Good morning, Chief Ogwuche, and thank you for joining us on the morning show.
Thank you for inviting me here. Let me correct one interpretation. I'm not an indigenous of Rivers State. I'm a resident of Rivers State.
Oh, yeah,
Thank you very much for inviting me.
Whether resident or indigent, the Constitution says you can live anywhere in any part of Nigeria. It doesn't really matter. Yeah. But what's your take on this latest ruling by Justice Wali regarding the tussle over membership of the Rivers State House of Assembly?
Yes, since this controversy started sometime last year, we've been meeting with a lot of surprises, both from the judiciary and from the political gladiators who want to take advantage of any opportunity or privilege to get what they want. And incidentally, they find the justice system, the justice sector, or rather the judicial system, a ready and available platform to maneuver and see what they can do with their tinkering with political gymnastics. The judge, Honorable Justice Wali, had earlier given an interim order to that effect. That interim order was the interlocutory decision he made yesterday. And you will recall that several other courts have made orders regarding the subject matter before that judge, which translates to just two things, two issues for determination. Firstly, the constitutionality of the defection of the members of the House of Assembly. Secondly, the validity of the instruments of the peace agreement signed between the parties, the warring parties, which was brokered by Mr. President. And incidentally, I don't know how this thing multiplied and fecunded into about 13 or 14 litigations in several courts. As a matter of fact, no court had made any pronouncement on the nitty-gritty or substance of the controversy, which is purely constitutional. And I guess that what was flowing from that direction is not very palatable for those of us who are in the legal practice, because you see orders of court impinging against themselves, conflicts in decisions and orders of court, which has sort of become a very serious erosion to judicial integrity. To the very best of my knowledge, the problem was created by the Constitution itself, because it gave a concurrency of jurisdiction to both the State High Court and the Federal High Court on the subject matter of the membership of the House of Assembly. I think the drafters of the Constitution, I do not see the wisdom they have in it, because we are talking about state autonomy. How does that work? Section 119 itself is also saying that the National Assembly can make law for the membership tenure of the members of the House of Assembly and as to the vacancy of the seats of the National Assembly. So it's even within the ambit of the National Assembly. Then I begin to ask myself, what sort of federalism is this? Professor Isawa Ilago had rightly coined it as a unitary federalism. I don't know where that exists anywhere in the world, but the autonomy of the states must be recognized. It must be very, very well, clearly stated as it is contained in the Constitution. There's no total formal structure that you call a federal system in our country. There are overlapping of powers and functions, but when it comes to the judicial sphere, I think jurisdiction should be very, very clear and unambiguous. The line of delineation has been set by the Constitution. Under Section 251, the Federal High Court has exclusive jurisdictions to certain areas. the state high court has unlimited jurisdiction. So when it comes to that point of convergence, constitutional convergence, particularly when it comes to interpretation of the organic instrument, which is the Constitution, I think there must be some bit of synergy or some sort of cooperation between both courts, even though they are at different parallels to each other, so that you don't have this kind of situation we are saying in River State.
All right. Thank you, Chief Ogwuche. Now, something else that has come under scrutiny or conversation is the issue of quorum, and especially with regards to the new, the remaining lawmakers. With this ruling, what will then happen? Is it legal for just them to sit? Can they pass laws as they exist? And then what would be the next steps in terms of filling those spaces? But at the moment, can they pass laws for those who have been who remain in the House?
To the very best of my knowledge, I think that the confusion arising from this controversy is essentially because nobody has gone headlong to tackle the issues, the constitutional questions raised. And if that had been done and the matter had gone straightforwardly into that adjudication, I guess by now we will have gotten a very clear picture of what is on the ground. But to the very best of my knowledge, you cannot circumvent provisions of the Constitution. And it's not even a matter that, that should even go for litigation as far as I'm concerned, except for the fact that politicians want to use the courts to see how they can maneuver, underhand maneuvers and rigmaroling. The issue of defection is clearly stated in the Constitution, Section 119 says it. The issue of the validity of the instrument is very clear, that you cannot bring extraneous instruments to regulate the provisions of the Constitution or regulate governance. It must be within the ambit of the Constitution. So why the recourse to the courts? But the recourse to the courts becomes necessary because politicians want to have their way. But then the those members of the House of Assembly that are remaining do not form a quorum. As far as I'm concerned, they cannot validly make any law, make any regulation, or do anything whatsoever. There are, I think, a couple of cases pending before the Honorable Justice Obile of the Federal High Court and the Honorable Justice Abdul Malik of the Federal High Court asking that INEC conduct an election to those places. How far that one has gone, I do not know. But for now, we cannot rigmarole through the Constitution and think we can express a quorum that is not there, that is not so provided. What should be done is to quicken the process and ensure that probably INEC does the needful and conduct elections in that place to replace the members that have jumped ship. To continue to prolong it is totally antithetical to democratic norms. It's unfortunate that the members left them in the manner they did, and having done that, I think a second chance is there for them to stand for elections and see whether they will come back. I believe if they are very popular with the constituents, they definitely will return. But to the extent that I understand the Constitution, you don't maneuver through it, and so the three members or the few members that are there do not constitute, as it is, membership of the House of Assembly of Rivers State.
Okay, Chief, it's Section 96 of the Constitution that deals with quorum. And what it says very clearly is that to form a quorum for the Parliament to be competent to act, it must have 1/3 of the members of the House. The Rivers State House of Assembly has 32 constituencies. One died, I think Lolo, MP, died in September 2023. Then, of course, Edison went on to become Chief of Staff. So that's why now you just have about, in total about 30 or maybe 29 members of that House. Now, you have said it, that 3 members cannot form a quorum, because if you look at Section 96, dealing with quorum of Parliament, then of course 3 people should not sit down. However, do you consider what is happening in the courts an aberration? I thought that the substantive matter had already been determined at the interlocutory level, and the affected 25 lawmakers, I think they have a case in court on appeal. Once a case is on appeal, will it also be right to say they are no longer members when the subject matter, the rest of the matter, has not yet been determined? What do you think?
That's a very good question. But recall that section 109, if you read it in its entirety, is totally clear and unambiguous. And it is self-executing. Self-executing in the sense that you don't need any interpretation of the court to implement it. It is not all the provisions in the Constitution that require the interpretation of the courts. When it is unambiguous, it is clear, it is without any solid part here and there, of course, you're bound to respect it right from that onset. Immediately they have moved. They have crossed the Rubicon of their membership, and that then the provisions of the Constitution will take immediate effect. They have gone to court to ventilate their rights, to assuage their rights. Yes, they are citizens of the Federal Republic of Nigeria. The rule of law allows them to do that. The principles of justice allow them to do that. But it is not that they remain on that seat until their matter is determined. No, it cannot. It doesn't go that way. Certain provisions are there, particularly with elections. Sorry, you were saying something.
Yeah, but you know, sir, this section 109 that you quoted, that same section 109 at 1G talks about if there is division within the party. That's what the courts will prove, as we have seen in our Abegunde versus Ondo State House of Assembly. And that has not yet been determined. So we have not reached the end of the argument.
Well, when we say that a constitution is self-executing, we're also saying at the same time that the constitution will take cognizance of the ambience that exists at the time that such action was taken. Was there division? Was there anything hovering around the political atmosphere that would suggest that section 109G would apply? That's the whole thing. And even if there's anything or nothing, first of all, you align it with the pattern it is done probably in the United States, or maybe let's look at the United Kingdom, that once a member of parliament jumps ship, the next thing is for council elections to be conducted. And that's the crux of the matter. Even though they have that proviso and they are claiming that their defection was justified, I would say that by the nature and circumstance of what transpired at that time, it is something that they should definitely move away from the House. And if they have a case in court and there's a prima facie evidence that, yes, there was actually something that substantiates to section 109G, then it can be properly looked at. Probably that's why INEC is withholding its hands, because they are in court. You know, there's also a matter in court pending saying that INEC should proceed and conduct election and withdraw their membership, declare them their seats vacant. That's what has to go side by side. The only unfortunate thing is that we have this plethora of cases surrounding very simple issues that ought to have been taken care of within a couple of months. And that's why we're saying that there's a new insertion of a provision in the rules of courts for non-multiplicity of actions. But then people take advantage of it because it pertains to cases brought by the same parties on the same subject matter. So different parties can now have the license to go around and begin to go across all the courts. And we are saying that there should be synergy. There must be a mechanism by which this type of attitude can be curtailed, because at the end of the day, the courts will begin to give different judgments and make conflicting orders. And they begin to corrode on judicial integrity. As far as I'm concerned, it is something that will require some very serious mechanism to get the courts to function appropriately in accordance with the law, not in accordance with the whims and caprices of political elites.
Well, that's why we have the NJC. The NJC has its work cut out for it.
All right. Well,
exactly.
Haven't answered the question on quorum. Then what happens to some of the decisions or motions passed by is it 3-man or 4-man members of the House of Assembly? Does it make it null and void? And then also going forward, then it means that they're in a deadlock. Because if you're saying that they don't have quorum, then they're just sitting. They can't do anything. They can't, pass any motion according to what you've analyzed. How then would legislative functions go on in River State?
That's exactly what I'm saying. And you've answered that question in part, that anything they've done so far in that capacity is a nullity. Any action they've taken in that capacity is a nullity. I would say that maybe if you can give it the coinage of their membership as being legislatures in abeyance, because they are just there. They cannot proceed to make anything. The constitution provisions, like I said, cannot be circumvented. The provisions are sacrosanct, and that's what we are trying to say. And the political elites must be properly educated to that effect, that you don't take advantage of loopholes and leeways and subterfuges to maneuver through constitutional provisions anyhow you like. The situation here in Rivers State is quite regretful, and I think it's high time the courts will take a much tight stance on some of these matters that touch on constitutional interpretation, and some of the matters that also touch on the livelihood and the fortunes of politicians, particularly the ones that are hybrid, and see the extent to which some of these things can be curbed. The judiciary has not been getting a very good image in terms of public confidence, and it is very, very important that that confidence be restored as much as possible, and can only be done if we allow we do not allow these incessant moves by politicians that tend to constitute constitutional infractions or what have you. I think it was Ronald Dworkin, professor of jurisprudence at Yale University, that said that you do not sacrifice constitutional provisions on the altar of political expediency. That is very, very important. And we will say that the House of Assembly as it is will remain in abeyance until the matters are decided by court. And what the court will do also is to speed up the matters as fast as possible. And I also expect that the agency will wade into this case to ensure that judicial sanctity is not eroded unnecessarily by political gladiators, to the effect that where there's that point of convergence and a constitutional amendment to that effect is not possible, because we expect that that particular provision section 272 of the Constitution that gives concurrency of jurisdiction to the Federal High Court and the State High Court ought to be totally scrapped. I mean, it's a state matter. It's something that should fall squarely within the broad shoulders of state jurisdiction, the jurisdiction of the State High Court, and not one that will present itself as an object of squabble or an object of crisis or conflict between the Federal High Court and the High Court of States. We must, as much as possible, try to eliminate such areas that lead to certain infractions that are totally uncontemplated. I would say that the agency has a duty to that effect, so that even if there's something that can be done, let there be a synergy, a mechanism of synergy between the two chief judges of the Federal High Court and the chief judge of the judges of the state, to the effect that when such issue of controversy arises, they all meet and evolve a mechanism to curtail these floodgates of litigations that come into the courts by politicians seeking to circumvent or rigmarole around the subject matter without touching the substance of the case.
Well, as it is in Rivers State, so it seems also in Kano State, and His Lordship, the CJN, has summoned, the chief judges in the case of Kano. Maybe he has to do the same thing with regard to Rivers State. But let me ask you, this is...
okay.
All of this is in the context of 25 years of democracy, 1 year of the Tinubu administration. Now, what would you say all of this drama in Rivers State portends, for democracy in Rivers State and the people of Rivers State? You've talked about the judiciary, you've talked about the constitution. How about the people of Rivers State? Are they enjoying the drama? Are they benefiting from the drama?
The theatrics come with some bit of fun. Some are laughable, some are regrettable. People here are not very much averse to political happenings around them, in spite of the fact that they are not figured they are not figured into the political fortunes of the state to a large extent, or else if we go back in time, well, the court had declared Fubara the governor, but we all know what happened in the course of the conduct of the elections, but the people have accepted him. And I would say that the situation here portends danger, both for Rivers State and for democracy, and for the country as at large, because people are now beginning to understand the underpinnings of this crisis and what resulted to it, and they're not very comfortable with it. We must have some sense of a democratic ambience where people's power and people's authority dominates, not one that the political class or political elites will be the ones dancing in the theater, you know, masquerading themselves in the theater. And if it all boils down to certain attributes of our democracy that I find totally unpalatable. We all know what it is, that the people are the reservoir for the expression of sovereignty. So says chapter 2 of the Constitution relating to the fundamental objectives and directive principles of state policy. But to what extent is this sovereign attribute exercisable by the people? That in the course of all the controversies, in the course of all the peace agreements and everything, the Rivers people were never consulted. Did they tell anybody that referenda or plebiscite is not part of our constitution? It doesn't have to be written. It has to be expressly stated in every democratic instrument, even if it is not put down there. Even in unwritten constitution, referenda, plebiscites are conducted to seek people's opinion. The UK constitution, for instance, you can't see any constitution anywhere, and they say this is the constitution of the United Kingdom, but they exercise it. So when situations as this will require that even if there is a peace agreement, or even before the peace agreement, a referendum can be conducted to seek the people's opinion in these things. They are the ones that are purportedly said to have exercised their franchise and put those members there. So why leave them out of it? But then somebody is saying that they should be returned because there's a peace pact between 3 or 4 persons, which does not in any way concern them in any way. How do you get them to be bound by that peace agreement? That's why it is good that we revisit the manner we run our constitution, the manner we run our democratic system, and ensure that the principles and traditions of the constitution and democracy are followed religiously.
Well, thank you very much, Chief Festus Ogwuche, for joining us on The Morning Show.